Date, the 22nd of April 2014. Title, Letter to His Honor, Judge Thomas QC. P. Paragraph 1. Dear Your Honor, Judge Thomas QC. I write to you to make an application to have the court order dated the 9th of December 2013, reference 64/13, reviewed and terminated, given the particulars I lay out in this letter. The Bradford Metropolitan District City Council, acting as prosecutor, is looking to lay criminal charges against me of fraud by false representation or possibly theft. As yet, I am not sure exactly what statutory coded violation I have committed an offence against, which they are looking to eventually bring charges to level against me, given their response that their investigations are still ongoing. However, should at any point in the near future any charges ever be eventually forthcoming by the prosecutor, and levelled against me, then I will be looking to do the following. Section 1. 1. Contest jurisdiction, on the grounds that the prosecutor may have an undue influence over the courts, given the fact that the prosecutor is a local authority and wields extensive powers. I am more than happy to be tried in any other courtroom in the land which is not under the direct sphere of influence of the prosecutor. 2. When challenged, I will look to enter a not guilty plea to any charges that the prosecutor may want to lay against me, as I profusely contest any charge of offence and profess my innocence. 3. As the prosecutor is looking to eventually charge me with a criminal offence, I will be making a request for trial by jury, so that my peer group and members of the public may adjudicate on the guilt or innocence of any charges levelled against me and decide my fate. 4. I may choose to represent myself in person and act as litigant in person, where I may have legal advisers on hand to guide me through the judicial process. Heading 1, Aftermath of the Court Order. P2. Given that a proceeds of crime order was granted against me, without any prior notice or my awareness, under Your Honour's authority on the 9th of December 2013, I would like to take this opportunity to detail the consequential effect and aftermath of its execution. P3, Number 1. The Bradford Council Fraud Investigation Team instructed the police to come to my house on the 17th of December 2013, to arrest me on allegation of fraud or possibly theft. P4. I reside with 2 other family members, consisting of my elderly mother, in her 80s, suffering from dementia, and my disabled brother suffering from schizophrenia, both of whom do not fully understand or speak good English. P5. I was arrested from the scene, my home, without an arrest warrant and transported to the local police station and detained in custody, awaiting to be interviewed by the fraud investigators. P6, Number 2. In the meanwhile, back at my residence, my home was searched by the council fraud investigators in conjunction with the police, and my disabled brother's bedroom door lock was broken. My entire house was searched from top to bottom, as the fraud investigators looked to gather evidence. My bedroom was searched and all my private correspondences were rummaged through, as my home was being raided for possible evidence. P7. The family safe from my bedroom along with all our financial instruments were confiscated. This included banking instruments belonging to my deceased father and also one of my brothers, for whom I act as Public Guardianship Office, PGO, appointed deputy and receiver. The exact aim and objectives of the search is still unclear to me. The pretext that documents relating to care providers were needed as evidence was given, and yet these were clearly left behind and not taken. P8. At no stage were we presented with an arrest or search warrant at our home, or told the reasons why our home was being raided and what exactly they were searching for. P9, Number 3. During the raid, the only responsible adult remaining at my residence was my elderly mother. During my arrest, I had informed and reassured my mother that I was being arrested and she was not to worry. As I went to clear things up, I would return shortly. I left her in a calm and reassured state of mind, as well as my brother who, due to his mental health issues, becomes easily agitated. P10. During the raid, the police team invading my home kept the outside door open. Given that my mother is elderly and gets cold very quickly, she kept on requesting them to close the outside door. She kept on explaining to them closed door, but they could not understand her, as there was no one to interpret for her. She eventually got up and attempted to shut the ajar door herself, so as to leave it slightly open to prevent the cold coming in. Given that the door was open, she also wanted to remove the keys from the unlatched open door so as to ensure their safety. She wanted to ensure that, in the confusion, the household keys don't get lost. P11. At this stage the police officers, not understanding what she was attempting, possibly thinking that she has locked them in, began to panic and force the key from her hand. She kept on protesting that these are our keys and she would not give them up. She became hysterical and started to scream at them to let her go. She had to be physically restrained by the officers and sustained bruising on her arms, given that she kept on protesting so vehemently. She kept on shouting at them, "Why are you doing this? You know, Mum, you know, Mum." But they simply did not understand her or chose to be absent-minded. In her despair, she instinctively turned to the phone and attempted to make a call for help. The officers glibly inquired as to who she was calling and she said the police, however she didn't remember or know what number to dial. P12. At the time of the raid, my mother's care worker was present, carrying out her duties in the kitchen which is located at the basement of the house. Hearing the commotion she came upstairs to offer her assistance, but she was told by the officers not to interfere. Not having anyone else to turn to, my elderly mother ran to our neighbors to ask someone to come to her aid. Eventually a neighbor came and began to explain to her why the police was still on the scene following my arrest, and explained that the house was being searched due to the arrest. This was the reason why items were being confiscated and removed. P13, number 4. At the police station, I was held in custody for over 4 hours as there were delays in getting a free room. I was eventually interviewed by 2 council fraud investigators, one from Bradford Council and the second from Kirklees Council, regarding council direct payments made to my brother that they could not account for. As far as I could make out, they were alleging that I had stolen or defrauded them to a tune of over £144,000. I explained that I would be contesting any allegation and asked them to present me with their evidence and justify the intrusion into my life. I explained that I do not have any formal contractual relationship with them, and that I am under no obligation to cooperate with them. They presented me with 2 contracts, one regarding my late deceased father and the second regarding my brother, indicating that I had signed for them. I explained that these contracts are not valid and lawful, moreover they are not between me and them, and put me under no legal obligation. I refused to expand on any questions further, giving no comment on all the preceding questions. It became very apparent to me early on that this was a fishing exercise to find and create evidence to make a case against me. I refused to partake in this unlawful escapade, especially given the way I was being degraded and humiliated into acquiescing to their authority. P14. I was presented with information pertaining to my brother's bank account transactions and my bank transaction showing transfers occurring. The suggestion being presented that these were fraudulent transfers. I was asked to explain and justify this activity. I refused to comment on any such questions, not to infer or indicate guilt or any impropriety on my part, but simply because I wanted to establish that I am under no obligation to them. P15. I am more than happy to defend myself in a courtroom of law to any charges that anyone wishes to bring against me. However, I will not be looking to subject myself to defend or make counter-arguments to those who wish to make baseless claims, and then sit in arbitrary judgment over responses to questions they ask me. P16, number 5. I was eventually released from arrest, on police bail, without charge, under no conditions, after spending the whole day at the station. However, clearly after being presented with the court order under Your Honour's authority, strict and draconian financial restrictions have been placed not only on my life but also on my vulnerable family members' life and liberties. P17. On returning home, late in the evening, the full effects of the day's activities transpired. In my absence, the prosecutor had been attempting to put inadequate service provision in place under their obligation to my brother, which they had been failing on for a period approaching a year. Following this traumatizing episode, my mother, who was receiving support and assistance, under the same duty of care of the prosecutor's obligation, has now refused to allow any third party into our home. Due to her condition, she keeps on replaying this event over and over again in her head. She is constantly scared and fearful that the police will return. Again. My role as a family carer has now been made extensively more difficult by many degrees. H2. Prosecutors claim justification. P18. The prosecutor's claim arises from payments made to my brother under its obligation to him under their legal duty of care, and subsequently their inability to give an account of how these public funds were utilized. It is down to the prosecutor to gather evidence in a lawful manner and make their claim and lay any charges they wish against me. The scope of this is outside my interests and remains an onus on the prosecutor to make their case. What I am more interested in, and which remains the focus of my priorities, is their legal obligation to my brother and other family members. H3. Background. P19. The prosecutor's payments were stopped in early July 2012, without any formal consultation or forethought on the consequential impact of their decision, or due regard to the discharge of its obligation following the suspension of payments. Following this event, I have actively been working with the prosecutor to ensure that their obligation to my brother is subsequently maintained. P20. In August 2012, I was forced into a situation where I was obliged, acting on behalf of my brother, to terminate an employment contract, given that this was now unsustainable as the payments would be terminated between my brother and his personal assistant that helped him daily with support and activities. This employee then initiated employment tribunal proceedings against my brother, to which I unsuccessfully acted as defense. The employee had been wrongfully discharged without proper notice, given that we ourselves had not been given adequate notice by the prosecutor. P21. I ensured that in the meantime adequate alternative support provision was in place, by agency workers, for my brother with the remaining funds. The obligation for future support provision was transferred over to the prosecutor in September 2012. The prosecutor would be taking over the responsibilities of the contract with the agency, commencing from September. Once this had taken place, they attempted to reduce provisions and started to mismanage the arrangements. I had to intervene, yet again, and ensure that full support provisions remained as they were. Several disputes escalated between the agency and the prosecutor, which were ongoing in October 2012. In November 2012, I sat down with the prosecutor and found some resolution. Some disputes still lingered on, and in December 2013, under the influence of the prosecutor, the agency have commenced legal proceedings against my brother. I will once again look to act as his defense against any claims the agency is now looking to leverage against my brother. P22. The failure of the prosecutor to adequately handle the disputes with the agency resulted in poor quality of care being delivered to my brother. We highlighted our displeasure to the prosecutor and they forced a new agency on us in November 2012, without our full and informed consent. P23. Once again we highlighted some serious concerns regarding this new agency and requested alternative providers. This was denied, and in December 2012, my brother was involved in a car accident in the care of the agency staff member. I highlighted this to the prosecutor, that an agency which was endorsed by them has resulted in my brother getting seriously hurt. In January 2013, we continued to use the agency as we had no alternative, and I witnessed my brother's health and well-being begin to gradually decline. By February 2013, my brother started to exhibit serious health issues. I intervened and stopped further provision being put in place to ensure and safeguard his safety and well-being. This very same agency which was arranged by the prosecutor in November 2012 has now, in January 2014, been publicly disassociated by the prosecutor following serious shortcomings highlighted by the Care Quality Commission, CQC. Yet when I highlighted some major concerns regarding this agency in December 2012, my concerns were systematically marginalized and downplayed. The prosecutor maintains clear relationships with all care agencies in the district that it utilizes to meet its obligation when it serves their purpose, over and above any concerns service users or their carers may raise. P24, from February 2013 to December 2013. I have actively been looking to find a way forward for the prosecutor to live up to their legal obligation to my brother, which ensured his rights, liberties and freedoms are protected, without any success. In the meantime, covering the same time period outlined, I have actively been engaging the prosecutor in regard to its alternative obligation to my elderly mother to ensure adequate service provision are in place for her care. I have had to equally struggle with blatant obstructions and reluctance on the part of the prosecutor, once again failing to honor its legal obligations. I have personally had to intervene and ensure their well-being is maintained at some considerable personal expense on my resources. In the meantime, the prosecutor has been clearly financially profiteering from this situation and continues to do so, which they have staged, as they save money at my personal expense. It is in their financial and self-interest to keep and maintain the present status quo, as they appropriate my labor by proxy means and force me into a situation which can best be described as a form of slavery, whilst at the same time saving on costs and relinquishing all risks. I have been liaising with my local MP, in conjunction with the prosecutor, to find a solution to the outstanding issues to no avail, as no other parties are incentivized to resolve these matters. I proclaim that the primary focus of the prosecutor is and always has been the financial dimension, so as to save money, irrespective of its obligation and responsibilities to its duty of care. P25. Given this background, the prosecutor have been carrying out a covert undercover investigation against me during the time span mentioned, in order to discredit my character to ensure that I am disabled in my ability to publicly protest. Little did I know that during my time liaising with the prosecutor and raising legitimate complaints to them regarding their conduct on policies and procedures, there was a nefarious undercover investigation being carried out about me personally that everyone else was aware of other than me, preventing any real solution being implemented and making our meetings and discussions all a cruel, sinister facade. P26. My own personal life has been decimated by the actions of the prosecutor during these intervening months as they carry out their investigation. My personal health has drastically deteriorated and I have started treatment for stress. I have also started taking regular counseling therapy sessions to help me cope with the depression. In my opinion, the conduct and behavior of the prosecutor is deplorable by any measure, as they clearly have a disregard for the rule of law and hold me in unprecedented contempt. H4. Pivotal figure. P27. The central figure in the dispute between me and the prosecutor is my brother and the issues surrounding care that he receives. My brother is a vulnerable adult with both mental and physical health issues, who can easily be taken advantage of and exploited by others. The prosecutor has a legal duty of care to my brother under several statutory legal obligations, which establishes a relationship between the two parties. Equally, I clearly have a biological relationship with my brother, but more importantly, I have a fiduciary trust relationship which we have established over the years. This makes our symbiotic bond strong and compels me to have a high obligation of an equal duty of care to him, as this is the basis of our relationship. The conflict between the two parties, the prosecutor and myself, is the nature and substance of these two relationships that has caused the feud between us, regarding the dominance of one over the other. The details and character of this feud remain outside the scope of this letter. I would however like to summarize the consequential effects of the intervening months since the prosecutor has re-established their relationship with my brother, after being neglectful for a number of years, which has some relevance and validity to this point I make. S2. 1. My brother has been neglected by the prosecutor for several years without appropriate supervision of his care in the community, opening him up to many potential risks. 2. On recontact, suspension and eventual termination of his funding without proper consultation increased uncertainty and mental risk. 3. Being forced into a situation where he had to discharge his personal assistant given the circumstances staged opened him to legal risk. 4. Having then to defend the legal proceeding brought against him following this discharge caused distress. 5. Taking on agency workers under duress and having to establish new relationships caused distress. 6. Now having to make legal defense against said agency causes distress and legal risk. 7. Forced into a new agency without consent. Violation of liberty. 8. Having health and safety violated by new agency workers, as was involved in a car accident. 9. Developing serious health issues due to agency involvement. Health risk. 10. Forced to suspend agency provision due to these failings. Distress and uncertainty. 11. Solely relying on support provision provided by me, his brother and primary carer, for nearly a year. Unacceptable risk and financial distress. 12. Targeting and victimizing primary carer. Extreme risk and distress. 13. Witnessing assault on mother in our own home. Extremely personal distress. 14. Having bedroom door vandalized and bedroom searched. Extremely personal distress. Violation on liberty. 15. For a period of 2 months following my arrest, serious health issues began to escalate. Personal distress and health risk. 16. Health issues turn acute and needed hospitalization. 17. Breakdown and conflict caused to primary carer relationship. Extreme health and safety risk, personal distress and violation on liberty. 18. Ongoing disputes. Continuation of many potential risks. P28. I hope that this gives a brief indication of some of the issues and related aspects surrounding the care aspect. I believe these factors have played an instrumental part on the decision of the prosecutor to pursue me with the claims that they are making against me by looking to discredit me and vilify my character. H5. Protest to MP. P29. Following my arrest and the raid on my home, me and my brother decided to stage a public protest. However, the practicalities of this undertaking were limited given the health issues my brother suffers. Now, considering that prior to my arrest, I had been actively engaging my local MP and making him fully aware of the situation that me and my family were facing for a period of 10 months, I thought this would be the correct platform to make our objections heard. The MP had in the past been dismissive and very reluctant to actively champion our cause, and was not really interested following the recent developments. He instructed his staff to no longer engage us. Stubbornly, we kept on returning to his office, in a sit-in protest for a period of 1.5 months starting in January 2014 to the 14th of February 2014. At which stage the MP refused to meet me any further. Unfortunately, at this stage my brother's health issues became acute and he went into hospital. H6. Hospital discharge. P30. Following a short stay in hospital my brother was ready for discharge. However, given the unprecedented circumstances I faced at home and the recent developments, I refused to allow him to be taken home into my care. I informed the discharge team at the hospital that if he was discharged into my care then there would be serious consequences, given that we have not had any service provision in place now for over a year. I shall refrain from digression by delving further into this incident, as much of the information can be gleaned from the letter I wrote to the prosecutor following his discharge, Appendix 5. P31. Suffice to say, currently, as of the date of writing this letter, no further progress has been made by the prosecutor to progress this matter further, as it clearly does not serve their financial agenda. However, at the same time it is costing me my liberty as they expropriate my labor and resources without my consent and under my duress. H7, Court of Protection Order. P32, as I alluded to earlier, I have a second brother who is currently in a nursing home paralyzed from the neck down. He sustained these injuries as a result of circumstances similar and reminiscing of the same actions by the prosecutor then in 2000 to 2003. As a result of this event, I approached the Public Guardianship Office, PGO, to act as his legal receiver and deputy. As a result of the consequence of the stringent measures of the court order of the 9th of December 2013, this PGO order has effectively become overridden and redundant as I cannot access funds belonging to my second brother. The bank have told me that your restraint order takes precedence, and it clearly states that I cannot have access to any financial accounts that I may have control over. We pay an annual fee, in excess of £325, for the maintenance of the PGO order, which has now been rendered obsolete. H8, Summary. P33, the prosecutor has been covertly investigating me for a period in excess of a year prior to my arrest. At my interview, they have failed to establish that a legally contractual relationship exists between us or has ever existed between us, thus putting me under any legal obligation to them. At the time of my arrest, the 12 months of covert evidence that they had gathered to date was insufficient to charge me with any crime. Therefore, the prosecutor initially instructed the police to bail me for a period of 3 months, while they continue their investigation. Without making contact or giving me any reason, they have now extended it by a further 6 months. It is my contention that they hope to do this indefinitely, with intent to fully destabilize my family and conduce anxiety and frustration to unhinge my mind. S3. I draw your Honour's attention to certain key facts. 1. Since the 17th of December 2013, neither I, nor my family members have had access to any of our own financial property. We are living on loans from family and friends. 2. My elderly mother is now refusing to take support provision arranged by the prosecutor. Therefore, I now have to fully take on this responsibility. 3. Since February 2013, a period over a year, I have been providing support provision to my disabled brother due to the reluctance of the prosecutor to make adequate provisions. 4. From the 14th of February 2014 to 18th 370 March 2014, my brother has been in hospital due to the indirect but consequential effects of actions taken against my family. 5. There currently remains an indefinite uncertainty as to where me and my family stand at present or for the near future, as I have a possible criminal charge looming over my head without any clarity and information to help me understand any of its particulars. I am clearly presumed arbitrarily guilty of some arbitrary crime by the prosecutor without clarity of my understanding. H9. Raise an objection. P34. As the prosecutor unilaterally extends the bail date now by a further 6 months, I duly raise an objection for the attention of your Honour, given that the prosecutor has already now had over 15 months to complete their investigation. They are now unilaterally looking to take a further 6 months and yet have failed to establish a shred of evidence to support their baseless claim. Me and my family of vulnerable adults are now having our lives, liberty and freedom seriously curtailed by their ineffective actions and calculated callous inactions. The prosecutor will be held accountable for these and many other serious wrongdoings, but at present, I have patiently allowed them to make and develop their case and present their findings to the courts. P35. It is my contention that the prosecutor is deliberately and with malice unnecessarily dragging things on, as they are well aware that this current state of affairs is continuing to have a torturous effect on me and my family. It is my opinion that they are deliberately adding unnecessary delays, in clear violation to the principles of habeas corpus. H10. Motion to carry forward. S4. I make a request to your Honour, for the consideration of either of the following motions to be carried. Option A. Termination. I terminate the court order dated the 9th of December 2013. 2. To extinguish the order's effects in full, without any further consequences. 3. Instruct the prosecutor to cease and desist on all further inquiries and actions in their investigations. 4. Instruct the prosecutor to hand over to me, the alleged offender, all investigation material collated during the investigation process in full disclosure. This is very important to me as this is my private and privileged information and I have a right to safeguard it against any misappropriate misuse. V. Following disclosure, to destroy all material gathered and held by the prosecutor during the investigation process in accordance with the Data Protection Act. 6. Instruct the prosecutor to provide a comprehensive report regarding its use of public resources to undertake the investigation and what progress they have, to date, made during their investigation. Giving their analysis of the cost-benefit and other criteria and decisions used in relation to the investigation. 7. To instruct the prosecutor to disclose to me, a private citizen, voter, ratepayer and member of the public, a full, complete and comprehensive disclosure of all information that the prosecutor holds outside the scope of this investigation, given that they are a publicly funded local authority. Under obligation of rights of access, on me and all members of my family. Our former direct requests, made under the authority of family members, have in the past been met with reluctance, stratagem and clear subterfuge. 8. To return all items confiscated by the prosecutor to their place of confiscation, in full. 9. To make good or pay reparation damages for all items damaged in the raid or as a result or consequence of their raid on our home or other actions taken against us. X. Make cost directions for time spent in administration and preparation for defense. Option B. Review. As the prosecutor has now extended the period of their investigation by a further 6 months, I make a request for Your Honor to deliberate in review on the facts of the case so far, to determine the strength of the prosecutor's case and likelihood of the prosecutor's claim being successful. Following this, I ask Your Honor to consider and deliberate if it is in the public interest for it to be pursued through the judicial system. I. Instruct the prosecutor to explain why they have extended their investigation period. 2. Determine if the reasons provided are adequate and justifiable. 3. If justifiable reasons are given, then request full disclosure of all investigation findings to date and case material. 4. Instruct the prosecutors to provide the envisioned completion date of the investigation. V. Inquire as to the current state of the case and its stage of development, highlighting delays and pitfalls. 6. Request all the items awaiting outcomes, which are causing delays, and request the anticipated timeframe of their completion. 7. On receipt of the investigation findings and subsequent case information, review merits and scope of the investigation. 8. Determine if the decision to extend the investigation by a further 6 months is justified and reasonable. 9. If the decision for the extension is upheld, then determine how best that we, me and my family, are to survive a further 6 months given the position, provision and conditions we have found ourselves in. X. Determine and ensure that during the extended bail period that the obligation and duty of care for me and my family are maintained and safeguarded. 11. The prosecutor has requested key codes to our family safe. I have refused to provide them these codes as I maintain that their actions are unlawful. It is the intention of the prosecutor to forcibly break into our safe. Please request from the prosecutor their supporting evidence that by breaking into our safe they will find the evidence they are looking for, so that Your Honor may decide on the strength and merit of their reasoning and give instruction and direction to them on their intentions. I maintain that by breaking into our safe is a direct violation of my privacy. I declare that there is no evidence that is to the interest of the prosecutor in our safe, only cash and valuable items belonging to me and family members. Option C. Commit to proceedings following review or subsequently. I. Instruct the prosecutor to commence proceedings, so I am in a position to make a defense, and answer to any charges brought before the courts to lay against me. 2. Remove all restrictions on my capital held in financial institutions, so I am in the best position to adequately make a defense and make appropriate provisions for my family. My assets include a property portfolio which has had sale restrictions placed on it already. This has been determined as having a sales retail value that far exceeds the amount the prosecutor is looking to claim. Should the prosecutor, in the unlikely event, be successful in their claim, this restriction is adequate to cover any such liabilities. There is no clear need to prevent me from accessing my own funds other than to disable me. 3. Instruct the prosecutor to return all items confiscated, especially our family safe, as this has many of my family's private and privileged items. Option D. Alternative discretion. Given all the information presented before Your Honor has the full discretion to determine a more fitting and appropriate course of action which should be undertaken. H11. Conclusion. P36. I am morally outraged, dismayed and disgusted at the way me and my family has been treated by the prosecutor, a local authority that is under a legal obligation, as a public functionary, to its obligation of a duty of care, not just now, but over a decade through our many interactions. Furthermore, it is shameful and a disgrace the way in which the prosecutor has been flagrant with the law and the legal process, and misappropriated the rights granted to others for its own self-interest. It is my opinion that prosecutors' actions and motives are malevolently underhanded, dastardly despicable and unlawfully criminal. P37. For every action there is an equal and opposite reaction. Given the unprecedented severity of the action taken against me, I have equally reacted unprecedentedly. Failing to get adequate help from my local MP, I have emailed every single Member of Parliament with my public SOS letter requesting help, Appendix 1. This same letter I have issued to the editors of the top 5 newspapers and any and all organizations which I feel would be of interest, and in a position to help me. Appendix 2 is my response letter to the prosecutor where I express my outrage. Appendix 3 are all communication letters between me and the prosecutor. Appendix 4 are copies of letters of my police bail notices. Appendix 5 is a letter to the prosecutor following my brother's discharge from BRI. I attach these items for your edification and perusal as background to my case. P38. I now make a request for action to be made on a suitable motion to be carried forward as detailed under H10. Signatory, kind regards, Mr. S. Hussain. Address, 20 Primary Way, Bradford, BD24RT. X, Copyright 2014.